Hello, I'm attorney Gloria Allred, and welcome to Know Your Rights. Today, I'm joined by one of the attorneys from my firm, Allred, Morocco, and Goldberg, and that's Kirby Canon. And together, we're going to explain the rights that a pregnant woman has in the workplace. Kirby, when should a pregnant employee advise her employer that she's pregnant?
Thank you, Gloria. A pregnancy can be a stressful time for the pregnant worker and their loved ones. Many pregnant employees will feel scared to tell their employers about their pregnancy for various reasons, primarily that they will have a negative reaction or that it would have a negative reaction on or outcome on their opportunities, remove them from future projects, discount their contributions or give them poor performance reviews or fire them. Fortunately, California laws protect pregnant workers from such discriminatory or retaliatory acts the moment an employer first becomes aware of the pregnancy. It is always up to the pregnant worker to decide when to share her pregnancy with her employer. There is no one-size-fits-all approach for when it is best to do so. However, when the pregnant worker makes the choice to disclose the pregnancy, it is essential that the pregnant employee clearly communicate that she's pregnant to her employer. Only then will she trigger California's protections against discrimination, harassment, or retaliation, amongst others.
Kirby, how should an employee tell her employer that she's pregnant?
Thank you, Gloria. Preferably in writing in order to avoid any confusion, misunderstanding, or doubts as to when the employer became aware of the worker's pregnancy.
And can the employee do it orally?
Yes, California law allows an employee to disclose the pregnancy orally or in writing. However, it is always better to do so in a writing, like in an email.
And what should a pregnant employee do if she needs to take time off from work for medical appointments before her due date?
While it may be difficult to determine exactly which dates and how often a pregnant worker will need time off from work to visit the doctor, an employer that requires these visits should do two things. First, provide as much advance and written notice as possible to an employer about any upcoming medical visits. Now the question is how? She must obtain and submit a written note from her healthcare provider stating that she will need to take the time off to go to her appointments and, if possible, identifying the dates for these visits.
And what rights does a pregnant employee have if she develops a medical condition because of her pregnancy prior to her going out on maternity leave?
That's a good question, Gloria. Thank you. The best thing a pregnant employer can do is provide as much notice as possible to her employer about any requests from accommodations relating to a pregnancy, health condition, health problems, or disabilities, or medical conditions. Again, like we said before, the best thing to do is as follows. 1, consult with your healthcare provider. 2, obtain a written note from that healthcare provider that clearly and succinctly identifies that you need a reasonable accommodation to help the pregnant worker remain employed or a medical leave of absence from work. And 3, after you get the note, submit it to your employer or your supervisor. The written notice is critical because it requires the employer to affirmatively engage in a dialogue with the employee, the employer, and the employee's healthcare provider in order to determine what the employer can or cannot do. But remember, employers cannot harass, retaliate, or discriminate against a pregnant employee for asking to take time off from work, requesting appointments, or requesting accommodations, or requesting a leave of absence for any pregnancy-related health problems, disabilities, or medical conditions.
Good points. And what other rights do pregnant employees have in the workplace?
Pregnant employees, like other employees in protected categories, have the same rights to have a workplace free of discrimination, harassment, and retaliation. For this specific example, this means that employers, among many other things, cannot treat pregnant employees differently or pay them less or consider them for different opportunities or lesser opportunities in the future. Also, employers, and this is very important, cannot assume that a pregnant employee either cannot or will not be able to continue performing the same duties or anything else in the future due to stereotypes based on gender, childbirth, or family responsibilities. Some, but not, apart from these protections that we've already discussed, there's also several other leave entitlements that depend on the size of the employer or the length the employee's been there. Some of these entitlements also come with job protections.
In California, what length of time may a pregnant employee take for maternity leave?
Thank you, Gloria. Like we said before, there's no one size fits all. So it really depends on when the employee took the maternity leave. For example, it really depends on the reasons the employee took the maternity leave. For example, was it a pregnancy-related medical condition or health problem, or was it for childbirth, or was it for a newborn baby? But in general, there are two primary leave-related entitlements. One is California gives up to 4 months of job-protected unpaid leave, leave of absence due to an employee's pregnancy, childbirth, or any other pregnancy-related medical conditions. There's also entitlements to baby bonding leave. And for certain employers of a certain size and employees who've been there for long enough, there's an additional 12 weeks of job-protected leave that an employee can take due to the birth of a child. This list is not exhaustive, as there are other options available depending on the circumstances.
What rights does an employee have if she wants to return to work after giving birth and after she's taken her maternity leave?
That's a great question. California law, depending on the size again and the length of the leave, has job protections for the pregnant employee. Two of those are the employee can either return to the same job or in certain circumstances to a comparable job. Now, if the mother is still disabled and requires an accommodation to return to work, we return to what we've mentioned before, which is visit your healthcare provider, get a note identifying what type of restrictions you're required to come back to work, submit that note to your employer, and again, start that dialogue, which would require the employer to communicate with you and in certain circumstances, your healthcare provider, to determine what can be done or not be done. Upon return, an employee also has rights related to lactation and accommodations as well. And any other employee who has been fired or has issues returning from maternity leave or with pregnancy as they're employed should call an experienced employment law attorney to discuss any specific situation or their specific situation.
Thank you, Kirby. This concludes our discussion regarding the rights of a pregnant employee in the workplace. Please note that the statements we made today are not meant to be provided as specific legal advice for any one particular case. And to all of you who have joined us today, thank you so much for watching. If you found this video helpful, feel free to share it with your friends. All of the prior episodes of Know Your Rights are available on our law firm's webpage, Allred, Morocco, and Goldberg. Meanwhile, if you have any specific questions about your own potential pregnancy discrimination claim, we are open, and we will continue to provide free, confidential consultations. We have vast experience helping our clients navigate this complex area of pregnancy law, and we've won a multi-million-dollar verdict for a client who was the victim of pregnancy discrimination. Take care, be safe, and remember to always know your rights.